Hello everyone, good evening. Please can everyone that is present, or can anyone rather just confirm if they can hear me?
I
I
can
can
hear
hear you.
you.
Yeah, all right, thank you so much for that. Good evening again, everyone. You're welcome to officially the first class for data privacy and protection course. Right, my name is Williams Dennis, or Dennis Williams, as whatever way. I will be your moderator for today. I can already see some of our mentors on call. Mr. Solomon, you're welcome, sir. I can also see Mr. Abraham. Thank you so much for joining us on time. Right, we'll be getting into the business of the day very soon. Right, so firstly, we'll be taking on our announcements. Basically, basically on announcements, will be for those who, if you see friends, family who are still interested or who are interested in the JIIPCC Mentorship and Internship program, right? They can still join in for the program. We'll be ending registration once it's the second week of. We'll be closing late registration once the second week has passed. And then for those who are still interested in the certificates, you can make payments. For those who are yet to complete their payments, they can still make payments to get the certification at the end of the program, right? So that's that for our announcements. We'll be going in to read our mentor's profile. Our first mentor for today is Mr. Abraham Otene. Please, I will not be reading everything on his profile because it's because of time, right? So I'll just read a little of it, and then you all can just go ahead and read through. It has been sent to your WhatsApp group rather, so you can go ahead and read through the profile of our mentors. Mr. Abraham obtained a Bachelor of Law degree from the University of Nigeria, graduating in the top 1% of his class. He proceeded to the Nigerian Law School for his compulsory one-year practical training program and emerged with first class honors, bagging the Director General Prize for first class and also emerging the best graduating students from Kano campus. He proceeded to cut his teeth in disputes resolution with the firm of F.O. Akinrele and Co., one of Nigeria's oldest law firm. During his practice at F.O. Akinrele and Co., he represented local and international businesses and government agencies in numerous litigation proceedings arising from business and transaction disputes, including trademark infringements and suits. After deepening his dispute resolution experience, Abraham decided to explore his transaction this side. So, decided to explore. Okay, sorry, I kind of got distracted. Where was I? Decided to explore the transactional advisory side of legal practice to get a rounded view of the law practice. He joined the firm OAKE Legal, where he was an active member of the corporate financial technology slash financial corporate finance slash technology media and telecoms group. His rich dispute resolution experience made him an asset in the dispute resolution group of OAKE Legals. During his time at OAKE Legals, he advised on multi-million-dollar transaction across the agri-business, media, and technology sector. Based on his dispute resolution experience, he also represents rented companies in corporate and commercial disputes, including trademark infringement suits. Please, for want of time, you can go ahead with our mentees can go ahead and still read on Mr. Abraham's profile, right? You can follow him on LinkedIn, and okay, it's also nice. It will also be nice to state that Mr. Abraham was also once a JIIPCC mentee, if I'm not mistaken. Thank you so much, sir, for joining us. You are a proof that one of the aims of JIIPCC, right, is to turn mentees also into mentors. Thank you for your dedication and your passion to this program, and you're welcome to today's session. Our second mentor for today is none other than our one and only Mr. Solomon Okedara. Solomon Okedara, barrister and solicitor of the Supreme Court of Nigeria, is a practicing legal practitioner and researcher with over 14 years post-call experience and outstanding expertise in human rights with a special bias for digital rights, including data protection and privacy, digital identity, online expression, intellectual property, e-commerce, tech, and corporate transaction and artificial intelligence, having an unusual knack for excellence and matchless client satisfaction, with a view of delivering maximal results armed with a peerless ability to create legal research analysis, delivering impressive results in review of law, legal principles, and standards. Solomon is a partner at Solomon Okedara and Co., a firm of barristers and solicitors, and co-founded Digital Rights Lawyers Initiative, a not-for-profit NGO that focuses on promotion and protection of digital rights. Solomon is a strategic litigation lawyer with a robust interest and proven expertise in freedom of expression, digital rights litigation. He has litigated on digital rights and freedom of expression subjects in courts across Nigeria up to the Supreme Court and has conducted cases at the ECOWAS courts, amongst others. Please, you can read further on Mr. Solomon's profile. We thank Mr. Solomon for always we on him to come mentor on this program. He has been with us for quite a number of years, and we want to say thank you, sir, for joining us. Our last but not least on our mentors profile, on our mentors list is Mr. Emmanuel Ewere. Emmanuel Ewere is an accomplished information technology law specialist with a wealth of experience in guiding clients through the intricate legal landscape of technology. With over 8 years of expertise in the field, he has been a trusted advisor on various legal matters related to information technology, including data privacy, cybersecurity, intellectual property, and e-commerce. Education has been a cornerstone for Emmanuel's professional journey. In 2015, he earned his call to the bar certification from the Nigerian Law School, building a solid foundation in general law. He further on his specialization in information technology law by a master's degree from the University of Tartu in Estonia. Prior to that, he completed his Bachelor of Law at Madonna University in Nigeria. Emmanuel's career has been marked by significant accomplishments and has held key roles in prestigious organizations as a business developer at Floorworld LLC in the United Arab Emirates. He managed various projects ensuring compliance and due diligence. He provided crucial counsel to clients on matters such as data privacy, cybersecurity, and intellectual property. Additionally, Emmanuel's skill in drafting contracts, conducting market research, and budgeting were instrumental in driving the success of various projects. Like I said with the other two mentors, for the other two mentors, if you'd like to know Mr. Emmanuel, please, you can go ahead and read through his profile. We'll also them our mentors profile on LinkedIn. You can follow through and also make connections with them. Thank you so much to our mentors for joining us for today's class. And with that, we'll be going straight into the subject matter of today. Our topic for today is introduction into data protection and privacy. And I would just like to call on Mr. Abraham first. I think he's still with us to just help us give an overview and oversight of what data protection is.
Hello, can you hear me?
Yes, sir, we can hear you.
Good evening, everyone. It's my pleasure. It's a pleasure being here. All right. Some years ago, I was on the other side of the table, if you like, and it gives me a lot of joy to be, speaking today. So data privacy is, so first, to put things in perspective, maybe probably all of you know, it's hot topic in every conversation currently, right? So basically it is, how will personal data be collected, processed, used, and ultimately disposed of? So it's that process, that flow from the collection to the disposal. That's what data privacy and protection, if you like, entails, right? So it involves a lot of issues, and it gets more interesting as you bring in the subject of artificial intelligence and the training of machines and all of that. So can you hear me?
Yes, we can hear you now.
Right. So I was just saying, it is the law, the rules, the regulations. I believe where there are lawyers or law students here. It's the laws, the regulations, the principles that govern, the collection, the use, the processing, transfer, if you like, and disposal of personal data. I think that's a basic conceptualization, if you like. So I'm not sure how much detail you want me to go into, but I would guess that you will guide me appropriately.
Okay, sir. You can just have 20 minutes to just maybe
Right.
brief us through what you would.
Right.
Thank you, sir.
All right. Thank you very much. So having said that, I know that there are, experts here basically in the GDPR, and by extension, Nigeria's data privacy and protection framework. I would start by saying that in the regulation of data across the world, there are really two models, right? You have what I may call the general model, and you have the sectoral model. So the general model is what you have within Europe, the GDPR, and also in Nigeria. So it is the model that provides for a single framework or a few laws and regulations that cover all areas, everything that concerns data, personal data, right? So you have one law, a few laws, just governing everything. On the flip side, you have what we may want to call the sectoral framework. That is what is obtainable in the US, for instance, where there is no central data protection, data privacy framework. What you have rather is a patch, a patch of laws here and there governing various sectors, right? And interestingly, it's in that area that my current work is in, right? So while I would leave the general approach for the experts, Mr. Kidara is here, and he will speak to those expertise. I'd just like to, bring you on to the other side of the world, how things work in the other side of the world, right? So in the US, for instance, and I'm not sure of any other country that adopts that mechanism, that structure, but in the US, for instance, like I said, you have these various sectors. So in the health sector, for instance, you have the Health Insurance Portability and Accountability Act. So it is what we call HIPAA. It is not a privacy regulation. It's not a privacy framework. It's an insurance framework, but it has very substantial provisions that govern data privacy, that govern data protection, right? And one thing you will notice as you move from the EU model, right, you will notice that for each of these frameworks, you now have, to go into the weeds, you now see all of the distinctions. Every of the framework, will have their distinctive definitions, their distinctive applications, right? For the HIPAA, for instance, you have what you may call the protected health information, right? So that relates to individually identifiable health information, what the GDPR will call data, right? So under the Health Insurance Act, you have information that can identify a person, identifiable health information, right? You also have things like covered entity is what what the GDPR will call data controller, talking about healthcare providers, health plans, clearinghouses, and then you have things like business associates, right? What the GDPR, for instance, we call data processors. These are the kinds of persons that process data that they receive from the covered entities, right? So when you come into a system that does not have this organized data privacy framework, you now begin to look at issues of preemption, right? So you are where the central government has authority to make laws and the individual states have authority to make laws. There's possibility for a clash, right? I think in Nigeria, you talk about covering the field, right? So preemption is basically the ability of an individual, of a central government, to make laws that will supersede those of a subnational government. And there are some of certain laws like that. For instance, you have the Controlling the Assault of Non-Solicited Pornography and Marketing Act. It preempts state laws that impose greater obligations. And that act really covers commercial electronic messages. Also, you have things like the private right of action, right? Interestingly, for the US model, because you have these laws that are everywhere, and for the most part, many of these laws are enforced by regulatory authorities. Many of the laws do not have private right of action, saying an individual cannot come to court. So if there's a violation, unlike the GDPR, where you can approach the CJEU, right? For these laws, you have to report to the regulatory authority, who will then carry out investigations and bring an action if they deem fit. So I said that to say that while the sectoral framework adopts a different model, right, there are still recurring themes, recurring principles, recurring issues as what you would see in a central model like the Nigerian model, tailored after the GDPR, and many other models in the world that are tailored after the GDPR. In fact, the GDPR Europe has become a force when it comes to data protection. There's now a thing known as Brussels effect, where the developments are happening in Brussels, the heart of the EU, right, is affecting development across the world, right? Because again, I believe we talk about it down the line with issues of data transfer, international transfer, and all of those things. So there are now strict rules from the GDPR for transfer, and countries have to, comply. They're going to be able to transfer, right? So it's now affecting, the impact is now being felt across the world. Even here in the US, you have several state laws. Almost all the states now have data protection and privacy laws and regulations. And many of them are tailored after the GDPR, right? Also, the US and the EU have had these very unpleasant history, right? Trying to craft frameworks for data transfer. I mean, I won't go into all of those details, but the point being, the influence of the GDPR is now being felt across the world, in Nigeria, here in the US, across the world. The impact of the GDPR is now being felt. So if you will be an expert, if you develop competence in this area, you should follow developments that are happening in the EU, right? There's an ongoing EU AI Act that has been negotiated, that will be voted, that will take effect, hope probably this year, I guess, right? So it's going to affect every other person across the world. So that's on how the interaction between the US system and the EU system. And I've used the EU system to have this side-by-side discussion, because I believe that for the most part, the structure of the EU is a similar structure with that Nigeria has, right? So I'll just run through a few laws and regulations. Like I said, for this sectoral approach, you have laws scattered all over the place. I've talked about the HIPAA, the Health Insurance Protection Act. We've talked about, there's also the Fair Credit Reporting Act. So that governs credit reporters, right? So in the US, almost everybody has a credit score, right? When you take loans, your credit score drops. When you pay back, it goes up. That's a simplistic definition, right? So as you deal with the financial system, your credit score goes up and down. So the credit report, almost everyone has a credit report that credit reporting agencies prepare, right? It just gives an overview on your spending culture, your spending, how your spending culture looks like, right? What's your financial outlook like? So there's a law that governs that, what they can gather, what they cannot gather, what they can disclose, liabilities, and all of that, right? So that is for the credit reporting industry. And there's what we call the Gramm-Leach-Bliley Act, GLBA, right? So that governs financial institutions, banks, and all those kinds of things. It talks about how they can transfer data with affiliates and non-affiliates, governs all of those. When you come to telecommunications and marketing, you have things like the Can-Spam Act. I mentioned it earlier, controlling the controlling the assault of non-solicited pornography and marketing. So the US is a huge market. From when you wake up in the morning, marketers are calling you, to when you sleep at night, they are bombarding you with calls. So there are rules that govern those practices, specifically telemarketing sales rule. It talks about when to call, issues around answering machine, how to details, information you are supposed to deliver, information you're supposed to obtain, all that kind of stuff. Then there's Video Privacy Protection Act, details about the videos that a person rents, the details of the person. Remember again that data really is personal information relating to an identified or identifiable individual. That's why all of these facts about a person can become important, right? When you always keep in mind what personal data is, right? Information relating to an identified or identifiable person. So certain information in themselves, if you have them in themselves, will not relate to anybody. But when you piece them together with certain other details, you can immediately know who that person is. Those kinds of information will be referred to as identifiable information, or information that relates to an identifiable person. While information that relates to an identified person is information that once you have them in and of themselves, you can know who they refer to. So information like name, maybe phone number, email address. Those are information that relate to an identified person, because once I see the name, I know, oh, it refers to X, right? But certain information like, IP address, they may not refer to a particular person, but you are able to make inferences, to connect them to somebody else. From much of the US, IP address is not considered protected, right? But I think in California it is protected. So California is like the most forward-looking state when it comes to data protection, right? So you also have things like the Children Online Privacy Protection Act that protects children activities online. Then you have things like the Family Education Rights and Privacy Act that protects educational records. So under that, you're looking at personally identifiable information instead of personal data, right? Personally identifiable information that, your name, your school login details, and all of those kinds of details will fall under what is defined as personally identifiable information. You have such things as education record. Then you have things like directory information. They do not exactly fall under what you refer to as personal data or personally identifiable information. I've talked about the fact that states also have their privacy laws that govern can you hear me?
Yes, sir. I think it's the person's network, but over
All
here
right.
from my view clearly.
All right. So you have states also having, a host of privacy laws that govern the whole privacy landscape, data protection and privacy landscape in the US. I was going to talk about how, the US differs from the world, the EU specifically, and of course the world when it comes to data protection and privacy, and which makes it exciting. So the US Constitution and the Bill of Rights play a major role in every law that is enacted, either at the state level or the federal level, right? So, and that is, it's for that reason that the EU is always at loggerheads with the US, right? Because every law has to pass through the scrutiny of certain provisions of the Bill of Rights, right? The Bill of Rights has a couple of amendments, to the US Constitution. The First Amendment is a very fierce provision, or is a keenly contested provision when it comes to privacy, and indeed every other law that is enacted, right? So the First Amendment protects certain rights, right? It says government shall not, it protects the freedom of religious expression. It's from the First Amendment you get issues of distinction between church and state. It protects freedom of expression, amongst other rights. And the freedom of expression is, Americans hold the freedom of expression as if it is life itself, right? So anything that threatens that provision, most likely the court will strike down that law, right? And I think recently in Ohio, a court struck down a law that is akin to Children Online Privacy Protection Act, because there was a certain provision on I think it says children above 16 years that governs how much can be shown to them, how much of their interaction with the service provider in the absence of their parents can be had, right? And sort of restricted that provision. And the court struck down the law to the extent that it was inconsistent with the First Amendment. So as legislators go to work, as Congress goes to work, everyone is always mindful of this law must not conflict with the First Amendment. And Europe, for instance, feels that the US is not very serious with privacy. When it comes to privacy, the US is nothing close, right? So those constitutional provisions create some kind of tension as you look at privacy in the US. And just to be noted, and of course, there are some principles that touch on. There are some principles that touch on. That they are like overarching principles, recurrent principles when you look at privacy, right? And really, they are overarching principles across the world, right? That's why intellectuals, researchers tell you that, look, there's really no difference between what you have in the US and in the EU, for instance, and by extension, other parts of the world, because these principles are overarching, they're cross-cutting, they're applicable in Asia, in the EU, in the US, everywhere. And they've come to refer to as the fair information practice principles. There are variations of the name and what the principles are, but essentially they are the same in substance, right? And a couple of them, there is notice, right? So you are supposed to, as a person that deals with personal data, you are supposed to give notice of, your practices, your collection practices, how you deal with the data, how what kind of data you collect. You're supposed to give notice of that kind of practice. And if you look at most websites, many websites, you will see that when you scroll to the bottom part of the website, you will see privacy notice or privacy policy, right? Where you can see, although almost nobody ever reads those things, right? But you can see those principles of or those how the company goes about personal data collection, use, processing, and disposal, right? Many US laws that talk about privacy, not at the federal level now, not at state, at the federal level, many US laws that talk about privacy do not create a specific requirement for notice, right? Although the health law, the health insurance law, and the GLBA, the one that applies to banks and other financial institutions, mandates that notice requirement, right? And but generally, companies, based on other frameworks and general business practice, provide those notices, right? Provide privacy notices, telling you that this is what we will do with your data. Then there's also consent, where you are. I wanted to highlight notice and consent primarily because of certain reasons, right? There's consent, where a person is supposed to consent to or agree to the processing of their data, right? And this is where the US and the EU go their separate ways again, right? Because in the US you have what we call, for the most part, opt-outs, and in the EU you have what you call opt-in, right? So basically, opt-in is don't process my data unless I tell you to process it, right? Opt-out is I will process your data unless you tell me not to process it. So the US sort of has a very vast, almost limitless, grants almost limitless powers to businesses to process data, right? Although there are some laws that require opt-in, but for the most part, that consent is an opt-out, is an opt-out, there's an opt-out provision, right? Or companies have, they're permitted to opt out, right? For regulation, in terms of agency, because of the sectoral nature of the data privacy framework or data privacy landscape, you have several agencies that are responsible for processing, for regulating businesses in terms of the processing of personal data, right? But there is a major agency of government that does the bulk of the regulation, and it's called the Federal Trade Commission, right? It has a very interesting history, right? That agency actually was, and is still responsible for antitrust governance in the US, but somehow their powers have extended into data privacy and data protection and the likes, right? Partly because there is a unique, there's a little provision in their establishing act, that gives them the powers to go against businesses for unfair and deceptive trade practices. Right, so they have used that provision to do a lot of things, right? Just think some few years ago, they slammed Facebook with a $5 billion fine, right? So they are really powerful. Businesses in the US are afraid of the FTC, right? They are really powerful. That was like the biggest fine they had ever slammed against a company, right? So how that applies in the term, in the context of notice, is the fact that how their powers work in the context of notice is that they look at your privacy notice, your privacy policy, look at what it provides for. If you are in breach of any of the provisions of your privacy notice or privacy policy, they come against you for deceptive practice. They proceed against you for deceptive practice. On the flip side, they look at your privacy notice, and if there are some practices that that are reasonable, and you do not make those provisions, they proceed against you for unfair practice, right? So that is how they proceed against companies. So companies have almost limitless powers to collect and use data almost without restriction. But when you say you will do something, they will hold you to what you say you will do, right? And there's been a lot of enforcement actions against companies, I think a very interesting one was Snapchat. Snapchat had, so how it works is when they believe you are in violation, they do the investigation. Ordinarily they should go to court, but for the most part, they don't. For the most part, it ends in a consent decree, which is just an agreement between the business and the FTC saying, we will do XYZ, we will not do XYZ, basically. All right. That consent decree is valid, it holds you for 20 years. But if you violate it, then they can now slam you with a fine. So Snapchat, I'll round off with this. Snapchat said their snaps disappear after a certain amount of time. Nobody can get a screenshot. Um, um, if anybody tries to get a screenshot, they will inform you. You know, they told you all of those things that their snaps will do or could not do. Then it turned out that number one, it was not expiring after the stated time. Number two, people were getting screenshots perpetually. Snaps is like what you have on WhatsApp status. I think, where it disappears after 24 hours. So because of those promises, the FTC proceeded against them. You said this, you said this, you said this. It was in your notice, you violated it. Now we're proceeding against you. So with that, I know that there's still a lot untouched, but I have decided to address issues from a different approach, because I know that for the most part, the bulk of your practice or the bulk of your study might have been around the GDPR and Nigeria's data protection regime. So I thought I could bring in a different perspective. Thank you very much.
Thank you so much, Mr. Abraham. Your perspective in itself has been really interesting and also an eye-opener to things and laws beyond our shores, and also things that generally affect us, saying that a lot of the laws that also relate to our lands are laws that are first and foremost implemented and looked at from other continents or other parts of the world. So thank you so much, sir, for that insightful session. We'll be having you later after the mentees presentation for your feedback on your presentation. But we also want to hear from our other mentors. I can see Mr. Emmanuel joined us while Mr. Abraham was still sharing. And before we have Mr. Solomon Okidara, I would just like for us to have Mr. Emmanuel come up first. So, Mr. Emmanuel, please, we would like to also have you come share your perspective on today's subject matter.
All right, thank you very much, Mr. Dennis, for hosting this very session. And I want to say kudos to Mr. Abraham that has really shed so much light and gave us a broader view of this introduction. And happy to know that Mr. Solomon is here. So I won't really talk much, because I know that as a group we have also prepared, and we know exactly what we're looking out for, what we're looking at here. But let me just give an overview so that we can get another understanding from my own view as well. So the digital age has come to stay, and it keeps developing, and Nigeria cannot be left out of this, because it's a global invasion, and therefore, if we don't catch up with the innovations, then definitely we'll be archaic. So Nigeria has made several efforts to see how they can meet up with the digital age system in regards to privacy and data protection. And when we talk about privacy and data protection in the digital age, in this our current age, we're looking at an instance where data has become a gold mine, a business entity. In fact, data has become something that is very valuable to the digital age. And for these big data holders, for these big companies, for these big users to actually enjoy their business and also carry out activities that can affect you as a person, they needed a regulatory framework to guide them. Now, the 1999 Constitution of Nigeria actually covered a little about privacy. And in fact, it tried to see how the right to privacy was captured in Section 36 of the 1999 Constitution. But nevertheless, it was limited to a lot of things. So there came the NDPR in 2019 that was brought in by NITDA. The full meaning of NITDA is the National Information Technology Development Agency. So the NDPR then became the primary regulatory framework for data protection in Nigeria, and it was more of an advisory law that regulation that covered the data protection, and also it regulated both the public and private sector. But in 2023, there came the Data Protection Act. This Data Protection Act came with its own flavor and punitive power. So while the NDPR was more of an advisory position, the DPA, that's the Data Protection Act, came with its own full force of enforcement and implementation. And this act covered for the rights and obligation of data controllers and processors, and also the data subjects. Now, I would like to make it clear that both the NDPR and the DPA, that's the Data Protection Act, still applies. The fact that the Data Protection Act came into did not invalidate the NDPR. So they both cover for data processing activities, including the collection, the storage, the disclosure, and the transfer of personal data. So as a student, I would like you to understand something, that for these data users, I would like you to have a layman picture of it. What do? They collect data, and when they collect data, they try to when you collect, you gather, you want to store it. So they store this data. After storage, they try to use it for their activities. Then some of them also share this data with other persons that are interested in your data. And this sharing could be domestic or international transfer of this data. So this regulatory framework is actually available to protect, starting from the collection to the storage, to the usage, to the disclosure, and also to the transfer of this data. So both the NDPR and the Data Protection Act act in both capacity, and it provides for transparency, for accountability, for purpose limitation, for data minimization, for accuracy, data limitation, integrity, confidentiality, and so on and so forth. And as a data subject, it covers for your right. It protects your right to be informed, your right to access to your data, your right to rectification, your right for erasure, and right to data portability, as well as I mentioned earlier, and right to restrict the processing of these data. So in general, the Data Protection Act came with a flavor of enforcement and penalty. And NITDA is actually responsible for enforcing the NDPR, while the DPA is enforced by the various government agencies. And non-compliance of this regulation can bring about penalties, fines, sanctions, and even imprisonment for those found guilty. So how will I sum up? Let me make a summary now of everything. So this is actually a good one for the country for trying to meet up with the digital age. But nevertheless, we still have some challenges that we're still facing in this regards. Challenges like awareness, like so many people are still wondering, they're still asking questions like, waiting they use my personal data for. In fact, why do I need why do I need protection for my personal data? Is it affecting me? Yes, it's affecting you in one way or the other. I will tell you some of the ways. Now, they can use your data to monitor you. They can use your data to give you so customized advertisement. They can know more about you. They can know your about your life, your your general day-to-day activities. So there's a lot that goes on in the digital realm with your personal data. So it must be protected. And our system must have to do more to meet up with the European standard, which Abraham actually gave so much light about, because they are actually setting a standard for the world to actually catch up with. So with this little view of mine, I believe that Mr. Solomon, who is super impactful and blessed with great knowledge, will also add more flesh to this introduction. Thank you very much.
Thank you so much, Mr. Emmanuel. Thank you for putting things to simple terms, trying to just get us to primarily understand what are the key concepts and how it affects us. And for now, we would like to just set the floor, or rather hand over the floor to Mr. Solomon to also come give us an overview of today's topic, Introduction to Data Privacy and Protection. You're welcome, sir. The floor is yours, sir.
Okay, so good evening, everyone. Can we hear me?
Yes, we can hear you, sir.
I don't know whether that is English. Mr. Emmanuel, can we hear me?
Nice to meet you, Mr. Solomon, this year. Happy New Year.
It's a pleasure. Happy New Year. And I'm here to get my Christmas chicken and the fowl and the rice. But then we'll get back to that. So, good evening, everyone. And for those who were coming together meeting for the first time, I will say it's a pleasure meeting you. For those who have met before, and this is our first time, meeting this year, or meeting, I will say a happy new year to you. I wish you an amazing 2024. Yes, so this is our first session, and I've actually patiently listened to our first two mentors. That's Mr. Abraham and Mr. Mane. Of course, they have actually given a very fantastic foundation for whatever we're going to do. Trust me, my job here this evening is not to teach. And as a mentor, I'd rather see that role as one of triggering creative legal thinking in you. Some years back, in my uni days, I came across a book, and the book says, school does not teach you law. School only teaches you how to think. You teach yourself law through rigorous legal research. And that's actually a very brilliant view for me. So because it actually goes to the art of personal development, which is very best, for legal development also. And let me say this, because we are actually getting our hands, on an emerging legal field. I said emerging, not just only in Nigeria or Africa, but all over the world. Now, so all of us are actually blessed to have the pioneer status, so to say, as industry expert or enthusiast, or however you may want to see yourself. So my point here is, I'm just going to do a very basic job. And so when it comes to the concept of data protection and privacy, maybe someday, I'm going to share some of my works. And when I'm talking about works, I'm not talking about articles. I'm talking about works done for, multilateral institutions, European Investment Bank, World Bank, FDA, and all of them. So that have actually formed basis of their policy formulation for engagement with nations around the world, including African continent. So basically, when we are talking about data protection and privacy, let me for yet another time reiterate the fact that while those two concepts are closely related, like brothers or cousins, they do not mean exactly the same thing. There are instances where a violation of your personal data may not necessarily be a violation of your privacy. And so in some of the works I've actually done, or some of the institutions I mentioned, there are instances where I did a diagrammatic representation where a violation of one means a violation of the other, and where a violation of one does not even touch the other. So having left that, then we should know and bear in mind all the time that there are principles that govern the data protection regime. So you have the principle of data minimization, you have the principle of confidentiality, accountability, accuracy, and all of that. So one thing I will also let you know is that these principles do two things per time. In one time, a principle confers a duty on a duty bearer called data controller or data processor, or it could be joint processor. And at the same time, it confers a corresponding right on a data subject. So let me clarify that. Let me give an example of that. So there's a principle called accuracy, that personal data has to be accurate at all times. That principle of accuracy confers a duty on the data controller to ensure that the personal data of data subject it keeps or processes is accurate at all times. And in the same breath, it confers a right on data subject to make a demand on data controller to have his personal data kept accurate. And that goes to the root of a right called right to rectification on the part of data subject. So in that situation, then we speak to two stakeholders. We call one duty bearer, which includes the data controller, the data processor, the joint processor, and all of that. Then, of course, we go to the other side, and of course, we talk about the right holder. Now, in one of the consulting works I did for European Investment Bank, I added a third category of stakeholder. I call them right observers. So, and in that situation, I made reference to the academics, to civil society, community, and some other, stakeholders. So, the point here is that when you observe every of these principles for data protection regime, it confers in one breath a duty on the duty bearer, and it confers a corresponding right on the right holder. So, and of course, like I said, maybe most of us we're generally used to data controller, data subject. Yes, I have to bring in the concept duty bearer and right holder because look, when it comes to this principle, it is not only data controller that bears a duty, and that's why when your personal data is processed by your telco operator or your network provider, and your network provider hires a private company to process it, then your personal data is unlawfully processed, and you come up to say, look, you have a responsibility. You go to court, and while you go to court, you file a suit against your telco, operator, and you join the third party it hired. The only reason why you could join that third party is that third party bears a body, bears a duty, just like your telco operator. So it is, and it is in that sense, because it's also a duty bearer, that makes it responsible to you alongside the telco operator which hired it. So in the concept of understanding how duties are imposed and right is imposed, that is why we have come to understand them as not just as a data subject or data controller or data processor or joint processor or data protection officer, but as duty bearers. They bear a duty to the right holder, which is data subject in this instance. So having said that, I think pretty much of what I would do and what I love to do is to have the mentees do their presentations, not just read to us what they have put together, but their understanding of application of laws, principles, and of course, case law, most importantly. I think I've said it countless times on this platform. Enough of us trying to come up, of mentees giving us the presentation that are devoid of case law, even if it is one or two, local or foreign case law. Please let us see how our courts have interpreted principles of data protection, how they have been given judicial pronouncement, and how the supervisory authorities in respective jurisdiction have been able to give their verdict, in respective situations. So at this point, I think I will hold it here and have mentees make their presentation. Then while I come back to give my thoughts. Thank you.
Thank you very much, sir, for that very wonderful introduction. And you set the precedence for our next session, which is mentees presentation, right? So we would like to have our mentees come up and make presentations, their presentation, group 1 and group 2, right? If you are ready, the floor is yours. Group 1, please, can you come up and make your presentation? Kindly do that very quick. Presentation time is 7 minutes. So we would like that to be very fast. Group 1, please come up and make your presentation if you are ready. If the group presenter is not ready, please can the backup presenter or someone within the group try to make the presentation for group 1. If group 1 is not ready, then we'll be going straight to group 2. Group 2, are you ready for your presentation?
I'm ready. Group 1 is ready.
All right, please go ahead and make your presentation.
Okay, I'm coming. Trying to.
You can share your screen now.
Yeah, I'm trying to open it.
If you're having issues sharing your screen, please can someone from your group also, can someone from her group help share screen for her? Please, you can go ahead and start off without the slides. I will try and see if I can find them and also help you share. Thank you. Group presenter, can you hear me?
Yes, I can hear you.
Yes, I said you can go ahead and start the presentation. I will help you find the slides and share.
Okay. Good evening, everyone. Good evening, everyone. My name is Winna Ayewo, and I'll be handling the presentation for Group 1. Okay, our topic is an introduction to data privacy and protection. Can you all hear me?
Yes, we can. We can hear you.
Okay. The topic is data privacy and data protection. We'll start by defining what data is. Data has been defined as set of information of any individual which may be measured, collected, reported, or analyzed. Okay. Then definition of data protection and data privacy. Data privacy is the ability for a person to determine when, how, and to what extent personal information about themselves is shared, while data protection is a legal framework, the policies and laws put in place to safeguard information about an individual from illegal access, loss, or compromise. Simply put, data protection has to do with laws designed to protect our personal information. So, data over the years has become a very valuable asset. Hence, the need to protect it and regulate its use. This is why laws have been put in place to regulate data protection and data privacy. So in different jurisdictions, we have regulations for data protection and data privacy, such as the General Data Protection Regulation in EU. But in Nigeria, we have the Constitution of Federal Republic of Nigeria, Section 37, providing for the rights of citizens to data, to privacy, while we have the highest law that exclusively provides for data protection and privacy, which is the Nigeria Data Protection Act. Other ancillary provisions are the Freedom of Information Act 2011, the Cybercrime Prohibition Prevention Act 2015, National Health Act 2014, and so on and so forth. So we are moving on to the key concepts of data protection and data privacy. When we talk about the key concept of data protection, we are talking about the objective and the idea behind data protection and data privacy. One of such is the concept. One of such is consent must be expressly acquired from individuals before such individual data is being used or collected, accessed, etc. Data must be secured from unauthorized access, and before data can be accessed or used by a third party, compliance must be taken, compliance with appropriate laws, and must be, before data can be accessed by a third party, it must comply corporate law guiding data protection and data privacy. We also have accountability, which talks about the data controllers, those handling data, individual data, must be accountable on how these data are being accessed, and they have the responsibility to protect such data from illegal access, from compromise, and so on and so forth. Can you all hear me?
Yes, we can hear you. Please go ahead.
All right. Okay, like we've said, that data must be secured from unauthorized access and accuracy. Data must be accurate, data must be up to date and complete to ensure that it's reliable for the intended purpose. we'll move on to the principles of data protection and data privacy. What are the principles guiding data protection and data privacy? The principles are provided for in different regulations in Nigeria, like the Data Protection Regulation and the Nigeria Data Protection Act. But we'll summarize these principles. So the principles provide that for individual data to be accessed or used, it must be legally accessed. In other words, you cannot pass corner to access those data or personal information. It must be used for the specified purpose which it was collected. Then C, data controllers and data processors, that's those in charge of individual data, has the duty of care and accountability to ensure that such data must be protected from corruption, from illegal access or compromise. Then 4, data must be stored only for the period within which it is needed. Also, Section 5 sub 1 of the Nigeria Data Protection Regulation provides that collection of personal data must be adequate, accurate, and without prejudice to dignity of human person. Then Section 5 sub 1D also provides that personal data must be secured against all foreseeable hazard and breaches such as theft, cyber attack, viral attack, dissemination, manipulations of any kind, and so on and so forth. That is the end of my presentation for Group 1. I hope you all enjoyed it.
Thank you very much, our presenter, Winner. Thank you so much for stepping up and presenting for your group. Can we have Group 2 make their presentation also so that we can have comments from our mentors, feedbacks from our mentors? Please, Group 2, if you're ready, if the group presenter is ready, please come and make your presentation. Can we have the group presenter for Group 2? The group presenter or the backup presenter, are you ready? Okay, I don't know what the problem is. Group 2, why are you not coming up to make your presentation? Please, can you all quickly do that so that we can move on to the next segment? Okay, Mr. Nathaniel, are you the presenter?
I am not the presenter for Group 2. I don't, someone else was supposed to present, but we haven't seen our slides. But just to step in, I would like to make reference to some case laws where data practices have actually been commented on, just like Mr. Solomon said. I just want to chip in a few things concerning case law. Is that okay?
Yes, please go ahead, Mr. Nathaniel.
Okay, thank you so much, sir. Thank you very much. So my name is Nathaniel Osage, and our topic is actually Introduction to Data Privacy and Protection, Legal Key Concepts and Principles. But I would like to weigh in on case law affecting data privacy. And fundamentally or essentially, data privacy is a fundamental human right that is protected by most privacy regimes across the world. We have the Universal Declaration of Human Rights that protects the right to privacy in Article 12. And here in Nigeria, we have our constitution, the Constitution of the Federal Republic of Nigeria, that guarantees the right to privacy in Section 37. And the courts here in Nigeria have actually made remarks, or they've given their opinion in a few cases in different ramifications. Can you hear me, please?
We can hear you. Please
Hello?
go ahead. Yes, we can hear you.
Okay, thank you. All right. So the case law on privacy interest cuts across areas like the appropriation of name or likeness. Okay, the appropriation of name or likeness, which has to do with the unauthorized use of the name, likeness, or image of a person, the private individual, for commercial purposes. And in that direction, a 2021 case was decided upon by the Court of Appeal. The name of the case is by Courtney Aviation Services Limited and Kelani. By Courtney Aviation Services Limited and Kelani. In that case, an aviation company actually used the picture of a traveler to advertise on an airport billboard without the consent of the traveler. So the court held that the privacy of the traveler includes his exclusive right to the photograph, which should not have been used for making any advertisement without his consent. And the case was held, judgment was entered in his favor. Can you hear me, please?
We can still hear you, Nathaniel.
Okay. So the contention of the traveler, who was the respondent in that the use of his photograph for advertisement on the aviation company's billboard was a breach of his privacy, and the court upheld that argument. And another privacy interest area is that of public disclosure of private facts. Public disclosure of private facts, and that was weighed in upon by the court in a 2013 case of Okon and Obo, where a libelous letter was addressed against the plaintiff. A libelous letter was addressed against the plaintiff. It contained condemning representations against. Hello?
We can hear you. We can hear you. Go ahead.
Okay. So a libelous letter addressed against the plaintiff was written and published in the public domain. And when the matter came to court, the respondent, that's the defendants, they sought to rely on the defense of justification that the contents of the letter were true. And the court held that whether the truth should in all circumstances be a defense is controversial in law. Okay. But in that circumstance, a letter containing damaging representations against a person can only be published if it's for the public benefit. So the court actually held that if that course is followed, it will introduce an indirect way it will introduce in an indirect way a limited form of liability for invasion of privacy by the revelation of embarrassing facts. So in essence, the court actually frowned against the publishing of misrepresentative representations against a person in public domain, private facts about a person in the public domain, against the pretext of justification. Okay, so those are just the few cases I stumbled upon and I thought I should share. So the court has actually thrown its weight behind the right to privacy of individuals in Nigeria in these cases. The first one is appropriation of image and likeness, and public disclosure of facts. I am still doing my research to find out others, because I'm actually very concerned about the practical aspects of the right to privacy and what the court has to say about it. Thank you very much.
Thank you so very much, Mr. Nathaniel, for stepping in for your group, and also helping us cite case studies on the subject matter for today. We would like to give the floor to our mentors again to come and give feedback to the presentations that were made. We would like to have Mr. Abraham first come give his feedback on the mentees presentation. Mr. Abraham, sir, the floor is yours.
Thank you very much for having me again. I also wanted to acknowledge the presentations first of the mentors and also the mentees. The good kudos on the work that's been done, right? Especially if you are just venturing into this space newly, right? It could be intense. So kudos on the work that's been done. I would just encourage that if this is something that you think that you want to do in the long run or add to other things you want to do, it will be good to go at it very intensely, right? And like Mr. Okidara said, there has to be a lot of readings, right? Because it's still an evolving area, right? It's still an evolving area. It's not like tort law, for instance, where when you say negligence, you just reel out the elements and you are good. The elements have been established for hundreds of years. So this is still an evolving area. It's going to require that you be on top of your game, right? Also, like I mentioned earlier on, it's a place that is it's becoming more relevant with regards to AI. So it's getting very interesting. I will see how that goes in the coming years. So I was going to say that is to get interested, is to get very passionate about it. It's not a time to dodge and say, oh, is that person's work or is this person's work? Everyone should get their hands on deck. The second thing I wanted to highlight is that distinction between privacy and data protection. And thankfully, Mr. Okeda made reference to it in his introductory statement. And you must keep that distinction clear in your head, right? What data protection is, for the most part, relates to personal information, and what privacy is. It could include a lot of other things. So, for instance, the references, public disclosure of private facts, appropriation of name or likeness. Some of those things they have their origins in tort, right? They have tortious origins or origins from tort law, right? So I just think it is necessary to always keep that distinction in mind, so that if you are fighting for data protection, if you are, you don't conflate it with privacy. It's they are in the same class for the most part, but it's good to always keep that distinction in mind. I would close by saying that I think that's a good start. If you want to commit to it for the long term, please ensure to be passionate about it. Thank you very much.
Thank you very much, Mr. Abraham, for sharing giving feedback to the presentations that were made, and also trying also to further improve in terms of their research. So thank you very much, sir. I would also like to have Mr. Emmanuel. Mr. Emmanuel, are you with us?
Yeah, I'm here. Yeah.
Please, I would like to also get your feedback
Okay.
on the presentation, sir.
Okay, I would like to note that from my experience so far with different mentees, this particular group seems to be like the most unserious I've seen. I believe that this is just the start point, and I believe they can do better. And I'll start first with slides. Usually we get slides before the session, and we go through the slides so that we can see where we can make input and also improve as well. But nevertheless, I would like to say that group two, I believe there are members of group two on this platform. Can you indicate on the chat? I'll just make an indication on the chat if you're a member of group two. Let's get members of group two, because it's amazing. It's shocking to see that you guys don't have your slide and somebody had to come up just to give a sketchy job, which is not which I'm not impressed with the entire group, not just the presenter even did well by coming forward. So let's get the members of group two. Let's see your hands, please. Indicate if you're a member of group two. Yeah, you have a slide, but where is the slide? You're supposed to present with your slide. We're supposed to see exactly what you're doing. It seems like you have to understand that you are about gaining knowledge about a, 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 a bigger field of now this is not just the normal the conventional system of our learning that you have been engaged. This is a new field. This is a field that you're about to become a voice. So you must give your real, in fact, all. You must give in your all to gain the basics here. So we have Rahman Oyedeji, we have Nathaniel. Who else in group two? Please, those that will not indicate right now, we need to take action against them so that they will know how serious this is, because we expect so much from you. Trust me, coming here, we don't even need to say much because we believe that you have done your little studies. We're just to guide you through and see how you can do better. So we have Rahman Oyedeji, we have Nathaniel Osagi, we have Awoyemila Taiwo. And are you guys just 5? You can unmute yourself. Those in group 2, you can unmute yourself. Unmute yourselves. Let's talk. All right. Are you guys just 5?
No, sir.
So where are the rest?
Uh,
No, sir, I'm not in
Like, sir,
group two.
I'd like to apologize on behalf of the group. I think the presenter did not get the memo that she was the one to present. She appeared shocked at the nick of time. She appeared like she never knew that she was the one to present, so she was ill prepared. But we had actually done our homework as a group. We actually contributed our own quota that was assigned to us. We put something together,
Okay.
but we couldn't come up with the slides, unfortunately. So we apologize for that, and we promise to do better going forward.
Oh, that's great. Then let's see better. Let's see more of let's see more commitment. Let's see better slide, better presentation next time from you guys, okay?
Okay, sir. Thank you very much.
And for group 1, let's go to group 1. So those in group 1, we have a good number here. And those in group 1, I would like to I'd like to ask some questions. So, and I would like you guys to answer to really show that you guys worked together. In your introductory part, did you guys really discuss the foundation of privacy and data protection, like foundation, especially using Nigeria as a case study? Group one, those in group one, can you answer, please?
Please, can we have group one mentees respond?
Sorry, sir. Good evening.
All
Sorry, I
right.
didn't hear your question. I'm a group one member.
All right. Did you guys discuss the foundation, like understand
Well,
how the whole concept of privacy and data protection came about, especially in Nigeria, using Nigeria to as a case study? Did you guys gain the understanding?
well, the way we shared our work, because we at first we didn't know that the deadline was on Wednesday. We thought deadline would be maybe a day before uh this our meeting now. But given that deadline was on Wednesday and people were not online, like some days to submission date, we just shared the work that everybody, like we shared ourselves in small parts for everybody to work on a particular section. Then we brought it together, and so we didn't have the time to like now go. But we later, it was when we had done submitting that we had the opportunity to now talk amongst ourselves, and then we realized that there are some things that we might have omitted during our using our slides or doing our work, and that's why the presenter had to add some things while she was presenting.
This guy abroad that mentored. You don't know what people have done for that white guy.
Because
Like,
this introductory part is
when
is
you
more
tell
of
the
you
lecturer
having that.
mentoring, they'll be like,
Someone's mic is someone talking? Okay, so this introductory part is basically to give you the foundation and basic knowledge about what we will be dealing with in subsequent weeks. So this is actually something that's supposed to prepare you ahead. You must get the basics. You must know exactly the foundation of what we'll be dealing on. And let me not stress much because I know that Mr. Solomon will do justice to this. Let me allow Mr. Solomon call for this. Mr. Solomon, please.
Okay, thank you so much, Mr. Emmanuel. And I really don't know. I'm trying to be choosy with my words. I realized, honestly, I've actually had to work in teams. I realized how damning the words of a team lead, of a mentor, of a teacher could be to the morale or growth of a team member. But at the same time, I realized that when people are not told the truth, when the spade is not called spade, you are only packaging a potential danger. Somebody will show up someday as an expert, and there is nothing to their name as an officer that can show that this person has knowledge of this field. So I don't know, somebody's microphone is on. Can we mute our microphones? We are not speaking up. If you want to speak, let me just mute mine and listen to you, please. Okay, so like I said, I mean, the least I could say to be, I mean, in avoidance of having to sound caustic, I would say I'm not impressed. I am definitely not impressed. And I think I would also have to drag the clothes of the management team of this current mentorship session a little bit. Yet, I know that they are doing their very best to bring all of us together, both mentees and mentors. But then I think it's also important for the mentees to be constantly reminded of the quality of the task expected of them. I've said this repeatedly. It is not permitted to come up with a presentation bereft of case law on data protection and privacy if all you would do is to cite the only cases conducted by Digital Rights Lawyers Initiative. Then you would have succeeded, giving us an idea of what data protection is all about. And trust me, we have even personally, in my practice, in a few cases I have in court, even in my name, most of the cases, 80% of the cases are cases I personally litigated, both at the trial court and at the appellate court in Nigeria. In fact, there was an address I had to specify that, my lord, the applicant humbly litigated this particular case before the Court of Appeal, this so division. And that, because that was actually the case, the respondent cited. You are citing a case that I litigated, and you are misleading the court. Are you joking? And you see, the amazing thing is that that judgment is not just only exclusive to Solomon. That was why the respondent is actually the federal government of Nigeria could actually bring it up. So I had to actually distinguish the holding of the court from a mere observation. I'm talking about the ratio, from obiter. I'm talking about, avoiding the court to be misled. But then, like I said, the counsel who made use of that case law was not part of that matter. Perhaps they don't even know when it was conducted. But because it's generally available, it's in most of our law reports. If it's not in a law report, you will see it when we just go online. Digital rights, cases in Nigeria, data protection cases in Nigeria, privacy. If you can't get them, ask me, ask JIIPCC. They will tell you, they will reach out to me. And to some other persons who have such cases. I mean, it is not encouraging if all you will have to make use of your time for is to come here and some persons just tell you the principle of data protection is this and that. So, I mean, you could have as well just sat down in the confines of your room and read it up. But what we are saying is that now some persons are designated mentors because they have gone ahead. They have perhaps litigated, perhaps they have consulted, perhaps they have taught, and they have had first-hand experience, handling these things beyond writing. But then it encourages them when they know that you have shown further interest than a mere or lame enthusiasm. There's a proverb in Yoruba language that says, "Omotoba shepa ni ya igbe," meaning it is that child that makes an attempt that is helped. Please, ladies and gentlemen, make effort to make that serious attempt. Let the mentors here, whether in data protection and privacy class or intellectual property class, let them see reason why they have to go all out for you. Please, let them see that the use of their time is worth it. So the very best of my knowledge as a date, no mentor on this program is paid. It's a giving back to the ecosystem for all of us. And we enjoy doing that. And I can tell you, many of us will still enjoy doing that for a very long time. But we are human. Let us see reasons that, look, it is worth it to spend 2 hours of my time sitting down with younger persons coming behind me, or friends or colleagues, and holding them by the hands and learning in the process too. So please, I beg you, in the name of God, from next session, please do the best you can, and do the best that you believe, you are convinced is acceptable. Give us reasons to clarify. Give us reasons to say, no, hold it. You see, in that case, this happened. Oh, from experience, while working on this, let's have robust conversation. If all you would do is just to put together some scanty principles, you type it and you send it, we will not really learn. We will only succeed in ticking some boxes, for God's sake. Give us reasons to say, oh, that's true. That's true. You know what? I came across a case. Next week, I'm going to actually bring it up and we'll share it. Let's have robust conversation. Let's have mind-blowing conversation. Why is it that at the trial court, the court will go this way, and at the appellate court, the court will go the other way? That's because of the dynamism of legal reasoning, of creative legal and judicial reasoning. And like I still reiterate, you cannot be coming here to present, and your presentation is bereft of case law when we have them both local and foreign authorities. Because those case law, they interpret the principles of law, the provisions of legislation and regulation. You see, whether wrongly applied or not, it's another thing. Even if you believe a principle or a legislation, or a statute provision is wrongly applied by the court, then that makes it beautiful for you to say, having said that, I disagree with the holding of the court. And I think on an appeal, the appellate court should be able to reverse this holding. Fantastic. It puts us on the edge of learning. And not just coming here to endorse whatever we present because we want to make us feel good. This is not a feel-good forum. And at the same time, I will retreat. And I believe every mentor here, loves you, wants the very best for you, will not run your esteem down. In fact, the reason why they have actually dedicated their time to show up is because they believe in you. They believe we all have that future together at the top of this practice, of this field. But please, justify, their sacrifice. Let's help them justify their sacrifice. Let them see that it is worth it being here every Saturday for 5 Saturdays at a row. So, guys, I believe that is taken, please. Hello?
Yes, sir, we can hear you, sir. Thank you very much, sir, for your feedback. Thank you very much to also Mr. Emmanuel. We sincerely also apologize from our end for not ensuring that due work was done by the mentees, but we will do well to make sure that everything is put in place ahead of next week's session, and that our mentees also do the necessary work that they can to make sure that their presentation is ready and is also well done. Thank you very much, sir, for that feedback. We will take all the necessary corrections that we need to. So it's time for questions and answers, the question and answer segment, right? So if you have any question as pertaining anything that the mentors said today, please, you can go ahead and ask your question. All kinds of questions will be kindly received, and we would make sure that our mentors try to their possible best to give their very best opinion on those matters. So please, do we have questions, live questions? We are taking questions. We would like to have our mentees ask questions.
So is somebody not asking questions? Okay, guys, I think it's actually quite important for us to lighten the atmosphere. And I saw a particular image, a couple of, I think I've seen it about three different occasions, and I intend to actually do a piece on it, a very comprehensive one, then bring in case law and all of that. So someone bought an item, and so for consumption, and the item, of course, when it was bought, usually when you go out there to buy something, maybe for consumption, they put it in the black cellophane, packet for you. Now, so that's why it's always black is because it needs to protect the content, the nature of the content that you've just bought. So, but that's why it's always black. But now, even with the black color, the nature, the content, everything about the content is quite visible. So people can see that this person is actually is going up to have a lunch, and this kind of the lunch this person is going to have. This is corn. I can see corn, I can see coconut. now, so to me, that goes to the root of privacy. I mean, it illustrates something in privacy. So, and if I'm going to start on that note, since you have all decided not to ask questions, so what are the principles of privacy that, or principle of data protection, or you bring privacy into it, that such situation illustrates? You have an item, you went to buy coconut and corn. I'm sure if I ask in this forum how many of us like coconut and corn, some people will still be, feeling, polished, whereas the person asking you loves coconut and he loves corn. I enjoy roasted corn and I love boiled corn. So, but if I ask, do you love pizza? I'm sure we'll see a couple of hands up. So that situation I gave on that position, what principles of data protection or privacy are illustrated? Anybody, any attempts?
We have a question from our mentor. If you can attempt the question, you can go ahead and raise your
I want to understand the context. Is it from the person they bought the corn from?
So this is the point. I really want you to be as liberal as possible. Whether you want to see it about principle. Now, so let me expand your horizon. You can choose to see principle. You can choose to see the duty of the person who sold the corn, and you can choose to see the right of the person who bought the corn. Just let us have the concept of data protection and privacy that's exemplified, illustrated in that image. Whether it's the principle and how they translate to duty and how they translate to right. I mean, I just want us to know on a very simple note how we understand those key concepts of data protection, of regime, before we even go into case law and all of that. Now, the presentations, we didn't have actually case law to deal with, to analyze, to disagree and agree with. So let's even see how basic understanding, how we have basic understanding of the data protection concept.
Good evening, sir. Sorry, can you hear me?
Yes, can hear you, Emmanuel.
I'm sorry, from what I was understanding, what is being asked is which principle is being shown by the person using the black leather to hide what was bought. That was what I understand Yes.
Okay, please go on, don't worry, go on.
From what I understood from the scenario you painted out, you're trying to ask like what principle could be observed from the person using the black leather to keep what was bought. Am I right?
Yes. What data protection concepts are illustrated in that scenario? Now, so let's just look at it. Solomon stepped out to buy corn. Okay, so he was having a meeting with a business partner. Let's say the business partner is from World Bank, for example. But Solomon has been, while the last 30 minutes of the conversation, his mind was no longer in that meeting. He was craving for his favorite snack, corn and coconuts. And he said, okay, Kevin, hold it a few minutes, give me a few minutes. And he tells Calvin he's going to be right back in about 10, 15 minutes. He needs to go. So Solomon steps out only to go to see Mama Chigozie, who sells corn and coconuts. So Mama Chigozie packs the corn and coconuts inside a cellophane bag for Solomon. And that black cellophane bag is clearly visible, like a clear bag, even though it's black. And you and I know naturally when you go to buy things and they put it inside that black nylon. Now, oftentimes you don't know what it is. Unless you move close, you begin to guess from the shape and all of that. But you are not supposed to be seeing everything clearly inside the black cellophane bag. So I'm asking, what data protection concepts are illustrated in that scenario?
I would say the concept of confidentiality.
Okay.
Because by not putting the things that were bought by, I think you said Solomon, I know hiding it or concealing it very well, the seller breached his or her duty of confidentiality that he or she owed to Solomon. And then Solomon was having an important meeting, as you said.
As a world-class consultant, now seen as as a voracious consumer of corn and coconut. Right?
Yes, so the principle of confidentiality has been breached. I don't know if it extends to I've forgotten this concept under the law of thoughts. I don't know if it extends to.
No, Emmanuel, this is not law of thought. So let's leave
okay,
it to.
I will just say the principle of confidentiality for now. Yes.
Thank you so much. So any other contribution?
Yeah, I think I also see data minimization.
Okay, how?
Like a data controller should try as much as possible to only use what they need.
How?
And data processing includes sharing. So if you're even going to share just what you need to share, which is the back of the nylon. And you don't have to share what is inside the nylon.
I do not want to dismiss your point. I would love you to clarify, to extend. I mean, perhaps there's somewhere you want to take us to. Now let me tell you this. Now, for everyone in this room, why you may find this illustration which you find it of interest is that, problems in real life do not come like the principles are stated or are taught. They come in very blurry manner that you have to expand the frontiers of knowledge. Sometimes you have to expand the known principles. You need to be creative. And that's actually what we have here. So that's why I hate people just being respect to the books. I mean, one of the things I enjoy about my practice of the field is that I litigate, regularly. I write, I research for an Ivy League institution on this subject, then I teach professionals on this subject. So I engage constantly. And I know that, as a matter of fact, it doesn't just come the way they are presented, even in case law. Sometimes you have the opportunity to disagree, to agree, and that's what I want in this class. Not just somebody coming to give us, these are the principles, confidentiality, consent. They don't just come that simple. A council may disagree with you. You may have to, to go back and look at it, expand the possibilities, and let the court be able to see how your risk, your thinking, your interpretation of it comes within the purview of the law. So somebody's raising up their hand. Who is that? Raman? Hello?
No, sir, it's Angel.
Okay, please. No, I think but Raman is making a point. Raman is making a point. Raman, can you finish your point, please?
Okay, I was trying to look at it from the angle of data minimization.
Okay, yes, I'm listening.
So, data protection and privacy applies to every step of the data lifecycle. So, from collection to processing to sharing and destruction. So, the principle of data minimization is to the effect that a data controller should only collect and process as much data as they need and nothing more.
I'm struggling to see. So are you saying by use of a transparent black cellophane bag, then more than necessary data was processed? Were you saying that's what was?
Yes.
Okay. Let me quickly. Does somebody agree with Raman? If you agree with that, if you disagree, can I have the reaction to Raman's opinion? Anybody? Okay, there's no reaction to Raman's opinion. So let's take a different thing. Okay,
yes,
Stanley.
Can I jump in? Okay.
Sorry,
Please.
I have something to say. I don't know, but like, is it processing or shared? Like, was it like too much was shared or too much was processed? I feel like what she's trying to say is too much was shared. In the sense that the cellophane is you can see through it, even though it's black. So that causes even though they are trying to protect the data, they are somehow still showing it to other people. I don't know if that makes sense. So it's not exactly, so the security is not tight.
Stanley, I got you. I see what you're trying to do. Yeah, I see what you're trying to do. And
I'm just trying to make
no,
exactly. Stanley gets my point. Like,
hey, you didn't get my point, but you didn't get your own point. Rava, don't worry, I'll call you again. Sit down. But even Stanley tried to stretch it, but I'm not sure that stretch will really stand. I'm not too sure. But I mean, Stanley, I appreciate the fact that you got Rava's point in that whole words. But I still do not think it stands. I do not think so yet. So any other opinion with that illustration?
I have other opinions, but not in regards to Rama's opinion.
Okay, yes, please tell me, Manuela.
Apart from confidentiality, in data privacy and protection, there should be consent. In that regard, Solomon should have given consent before any information showed about him could be published or could be made known to other people.
Emanuela.
Yes. Sir.
Emanuela.
Yes.
Emanuela.
I'm trying to get somewhere first.
Okay, get there.
Okay. Yeah, apart from that consent, is the duty. The seller had the duty to protect and secure the information or the data or the contents of whatever Solomon purchased from him or her by putting it in a leather bag that was very visible to everybody. The seller breached that duty of security and protection that he or she owed to Solomon.
Okay, so David Afolabi, are you in the class? Are you in the room?
Yes, sir. I'm here.
David,
hello?
David is your partner.
David,
hello?
do you want to react or you want to make your own opinion?
Yes, so I'm agreeing to what she said. So the
Okay.
seller has the duty of ensuring that the information of what I want to buy, which is maybe Gary and groundnut, is just between me and her. Nobody else should see it, unless of course I consent to it. But she has told me that, oh, she's giving me my Gary and groundnut in black nylon. However, it's actually transparent nylon, so everybody else can see it. And in that sense, my data is no longer confidential or secure as I would expect it to be. So yes, I agree with her.
Okay. Now, so let's do something.
Is it
Maybe,
clearly?
sorry. Please, if you are not speaking, can you mute your microphone?
Yes, please, can we have mentees mute their microphones until they are given the opportunity to speak?
Trust me, I would have loved to take this, to strike this, maybe for the next 30 minutes. But I also need to get into another meeting right now. But
Okay.
I'm going to ask calls. Can somebody immediately think of a principle of data protection regime that speaks directly to this? Okay, so let me ask you something.
Sorry.
Has any one of us come across a principle called PET? For short, PET is actually an acronym.
Did you say?
So,
what did you say?
I said, has anybody come across a principle called PET? PET.
Mm-hmm.
Okay, so PET is actually an acronym that stands for Privacy Enhancing Technologies. It's a principle that says, look, a data controller has a duty to ensure installation of privacy enhancing technology for data processing. So, and let me say this, in broader analysis, it is in the real sense installation of adequate privacy enhancing technology. The privacy enhancing technology required to keep personal data of members of JIIPCC, safe and private is not the same thing required to keep the telco operator's database. What is required for that is not the same thing required to keep the personal data of over 93 million Nigerian voters whose personal data are processed with INEC. What you have with INEC is not what is expected as adequate privacy, private enhancing technologies required for NIPSI to keep personal data of over 200 million people. So the question here is that black cellophane bag for the corn and coconuts, for the sumptuous snack of our of our respected consultant, an adequate privacy enhancing technology?
No, it's not.
It's not. Maybe in that situation, on a very light note, and on a very lighter note, what kind of privacy enhancing technology should have been used for that process?
Double the nylon.
An actual black nylon that could not be visible to see what was inside.
Double the nylon. Who said double the nylon?
Grandma.
Who? What's your name? Brahma.
Yes.
It's obvious you don't eat corn. I'm sure you eat pizza.
Maybe put the corn in newspaper. Put the corn in newspaper before putting it inside the nylon.
Who is that person? Who is that person who just spoke now?
It's Afolabi, sir.
Afolabi. We know ourselves now. Afolabi, do you eat suya?
Very well, sir.
I know. Leave them, Rama. Leave them. Now the high-profile babes. We ourselves, they call the WhatsApp group, the suya WhatsApp group. We know ourselves. So when you look at it, Raman, you realize that using a used newspaper to package, let's use the word package, to package or to process that personal data is actually a more adequate privacy enhancing technology for the personal data, for Solomon personal data in that system. Do you agree? Compared to doubling nylon. Do you agree,
sir.
Raman?
Yes, sir.
Well, at this stage, I am sure we are being able to pick one or two principles or concept of data protection, regime in that illustration. And trust me, around us every day, every moment, we see data protection issues springing up here and there is in the commonest, in the most regular of our daily interactions, transactions, and engagement. So what I've invited you to do this evening is that when issues come up, begin to put to use your data protection and privacy antenna, and that what are the data protection and privacy issues in this situation. If you do that, you will learn faster, better as a professional, other than just reading articles, reading text, and reading case law. Because look, let me tell you something. If somebody does not see a reason to litigate a particular issue, no matter of contravention of data protection and privacy such issues are, then such case will not get to court. So if they don't get to court, does it mean that there are no issues of contravention of data right or privacy right there? They are. So do you have to wait till all of these issues happen? No. For us to learn? No. So I challenge everyone in this situation. I mean, in this room this night. When you are coming back to class tomorrow, I said tomorrow, next week Saturday, please give us at least one simple, relatable, everyday issue around you, and give us how you will be able to pick at least 3 data protection concepts from them. This is an assignment, and I'm very serious about this. Okay? JIIPCC management, please. I hope we got that.
Yes, sir. Yes, sir. We'll make sure to include it into the attacks for the week, sir.
If they do not come up with this, I won't continue with this course. I want you to learn, please. I want you to learn, not just write. Some of the things you're going to put in your presentation, there are things you're going to get from people who have written. Some of those people who wrote, they only read. Some of those who read, I want you to be able to I want you to put your creative legal thinking to task. Tell us, challenge what we have known. Challenge them. Take me up. Take everybody up. Let us be able to learn from you. I mean, are we all together? Do we agree that's a very creative way to learn?
Yes, sir.
Emanuela, your voice is low.
Yes, sir.
You just want to do your presentation, your slides, you present and go.
Yes, sir.
My mentorship.
Yes, sir.
No, we don't, sir.
Guys, this is all. If this is about real-time learning, if it's not about box ticking, if it's about box ticking, you can stick to your slide presentation and get somebody to read them and say, hey, we have done it, hey, we are finished, hey, bye bye. No, I'm not here for that. I'm here for real-time learning. I have said this before, and I will say it again this evening. Application of knowledge is justification of its acquisition. That you can apply, or that you will be able to apply knowledge, is the only thing that justifies the reason you acquired it in the first instance. And until you are able to see these issues that you are learning around you, you may not be able to find yourself in a situation to apply it. If all you do is to just get that text, read the article, and the principles come here and purge it, you just no, it's not going to work. You're not going to learn. Look at a situation around you. It doesn't have to be something popular. And pick how you have been able to find. Okay, so there are about 2 academies, one in Nigeria, the other one in US, where I facilitate their privacy academies. And I had to take them up on the concept of PII. You know, when we're talking about data protection, we are talking about data that personally identify an individual. So, and I came up with the fact that there are direct PII, there are indirect PII. Direct PII are your name, your image, those set of data that directly identify you. But there are some other set of data that on their faces, they do not directly identify you. But when they are joined or they are traced, they identify you. They are also personal data. And so I took them up, in the respective classes. And many of them began to pick up, indirect PII around them. And for me, it becomes exciting to learn that way than principle of data protection, the right, the duty. At the end of the day, you can only pick them up and point them down. No, you are not learning. Put yourself on a threshold of creative learning. That when issue comes up, your data protection and privacy antenna setting, and you're able to sift through the situation and say, this is a data protection issue, this is not a data protection issue, this is a private issue, this is not. So that's what I want. I want you guys to learn. I want you guys to have mastery of it. Let us be able to sit down and challenge ourselves. Have your brief before the court, and let the court have to take a deep sigh. Please, that's what I want. And I trust you guys' capacity. I trust your learning inclination that you can not only meet my expectation, but you can exceed them. So, gentlemen, ladies, if there are, on this note, I'm going to hang my boots this evening until next week. Like I said, before I have your presentation, I want to learn from you. And I want you to prove to me that you are really learning and not ticking boxes. Thank you, and do have a pleasant evening.
Thank you so much, Mr. Solomon, for everything that you have said and everything you've pointed out tonight. We really do appreciate, and I'm sure our mentees have also taken so much notes from everything that the discourse you have brought up. So we would like to thank you once again, and we look forward to seeing you in our next session. To Mr. Emmanuel, sir, we still ask, do you still have any further contributions or anything you would like to point out, sir?
No, we've taken much time, and I just believe that both groups will try to get their slide earlier before the next session, and they'll be well prepared, and we'll do better interactions next time. Let's enjoy our interactions and create memories and knowledge. Thank you very much for today.
Thank you so much, Mr. Emmanuel, for your contribution. Thank you for your time, and thank you for your knowledge. With that, we've come to the end of today's session. Right, I want to encourage all our mentees to take what is going on here very serious, put in the time and put in the effort to carry out your research when they are sent to the group. Do well to have group conversations, hold group meetings, so that when you come to classes can be very interactive, and the sessions can be ever flourishing in that sense. So I would like to say good night, everyone, to our mentors in absentia. Good night to them, and also Mr. Emmanuel. Good night, sir. Take care, everyone, and enjoy the rest of your evening.
Thank you. Good night.
Yeah, good night.
Thank you. Good night.